In the 1950s, at the height of the Cold War against Russia, Americans were almost hysterically worried about whether there might be communists or communist sympathisers seeking to overthrow the US government from within. A phenomenon called McCarthyism emerged. Anyone accused of being a communist was dragged before a committee, presumed to be guilty, and was required to demonstrate their commitment to American values. It was all very dystopian. Konigsberg had been a social worker, an army officer in the Second World War, and later studied law. He had written editorials harshly critical of the US government, and in the early 1940s may have attended meetings of a communist group. He passed his examinations and sought admission as a legal practitioner. In California, as in Australia, the admission authority is required to determine whether an applicant is a fit and proper person, or in California, a person of good moral character. At a hearing, the authority asked Konigsberg outright if he was or ever had been a communist. He refused to answer, saying that the First Amendment to the US Constitution protected his right to his political views. Instead, he presented records of his community work as a social worker, his military record, and 42 glowing written references. The authority rejected his application for poor moral character because he refused to answer whether he was a communist and because he had written articles critical of the government. They also said that he had not convinced them that he did not support the overthrow of the US government. On appeal, the Supreme Court rejected the Californian decision. Along the way, they made some important observations about moral character as an eligibility criterion. The majority said, "The term good moral character is unusually ambiguous. It can be defined in an almost unlimited number of ways, for any definition will necessarily reflect the attitudes, experiences, and prejudices of the definer. Such a vague qualification, which is easily adapted to fit personal views and predilections, can be a dangerous instrument for arbitrary and discriminatory denial of the right to practice law." That same criticism may be made of Australia's system of admissions to this day. What does fit and proper mean? Can it be proved objectively? Should it be the criterion at all? Neither the USA nor Australia has a really satisfactory answer.